like you lost another one.
Welcome back to The Father's Advocate. I am your host, The Father's Advocate, Attorney Hughes. Last week, I presented a scenario and asked you all to give me your feedback, answer a few questions. And I did get a few answers. I'm going to try to answer the questions because I know that this scenario happens on a daily basis. And this is something I think dads really should understand. And as I said in the last week episode, is that if you understand why this scenario is so important and get the answers, you'll understand that the court system is not automatically or generally in favor of women. So the scenario is that mom and dad had a child. They were not married and they didn't get married after the child was born. As a result, mom goes to court and she asks the court to award her as the custodial parent as well as award her child support. Meanwhile, the court ordered dad to pay child support to mom and it to be deducted from his income or his payroll. Dad gets a new job, but he forgets to tell the new employer that he has to pay child support. So for all intents and purposes, dad is not paying child support. In the meantime, mom decides, hey, I need a break from this child. I'm not going to take care of him. You take care of him for a while. And so mom gets up and she leaves and drops the child off with dad. Her whereabouts are unknown. Fast forward, dad receives a letter in the mail from child support saying that he owes $30,000 in child support arrears. Dad is upset. There are three questions that were presented. The first question, should dad be upset? The second question is, what should dad have done before he received the notice? And then the third question is, what can dad do now? Well, as I told you last week, the first question's answer is no. Dad should not be upset. And why do I say this? Well, let me tell you. Irrespective of what kind of case you have, whether it's a criminal case, a family law case, a business case, you are in court, which means that you are under the scrutiny of strangers. They are going to watch everything you do. What that means for you is that you must cross every I and dot every T and be on your best behavior at all times. And in a nutshell, that means that you must be proactive with your case. It is your responsibility. Now, of course, if you have an attorney, the attorney can be responsible for that. But oftentimes, when a case has concluded, there is no attorney in that. So what that means in this type of scenario, when mom drops the child off, dad had a responsibility to let the court know the situation had changed. So with respect to the first question, should dad be upset? The answer is no, because dad had a responsibility to tell the court two things. Mom is no longer the custodial parent, even though the court had awarded her to be, because she dropped the child off at my house. The second thing dad had a duty to do was to let the court know that mom needs to pay me child support because I'm taking care of the child, and he didn't do that. And so as a result, the child support order is still in effect and dad is still required to pay. So let's answer these questions. What dad should have done first? First thing, without question, which most people got, is that dad should have told his employer that I need my child support to be taken out of my check. Because what that means is that you will not be in arrears. But what's most important, not that dad should have told his employer, but what dad should have done if he did nothing else was to go to court and seek to get that order modified. And that means get the order changed. And not just the order for child support, he needs to get the order for custody changed as well. And you may ask the question, why? Let me tell you. So first thing, with respect to the child support order, if the order is not modified, that order is still effective, which means that whether mom is gone for 5 years or 10 years or however many years she's gone, if she comes back and that order has not been modified, she can ask the court to make you pay that child support. And in Georgia and maybe other states as well, there's not a lot of forgiveness for child support arrears. There may be some scenarios or circumstances where you can ask for child support arrears to be modified, but I am not aware of it except from death. But we can deal with that issue a little bit later. In addition to asking the court to modify the child support, dad could also ask the court to make mom pay him child support, because after all, child support is not for the parent, it is for the benefit of the child. And in Georgia specifically, child support is geared to be able to maintain a certain lifestyle that the child would have if the child lived in a marital home or a home with two parents and two incomes. And that's the purpose. So dad could have asked the court, mom has gone, she's gone away, I don't know where she is, and I'm having to take care of this child, but mom should be responsible as well. But dad chose not to do it, and so now he's the one that's taking care of this child, not to mention the fact that he has an order for child support that he has not got or sought to have it amended or modified in any kind of way. The second thing dad should have did is ask the court to modify the custody award. Now, let me tell you, this is very, very, very important. And the reason for it is because, again, let's just say mom is gone for 4 or 5 years, whatever. And then she decides, I want to get my child back. Now, while she was gone, dad have no idea what she was doing. But she comes back to dad's house and she says, I want my child. And dad's like, oh, no, I don't know what's going on. I don't know where you've been. You're not taking him. And that sounds right? That's reasonable. But then mom calls the police and she has a copy of that order. What do you think the police are going to do? They're going to make you, the dad, turn that child over to the mom, because that's what the order says. Okay? Now, why is that also important to get it modified? Because let's just say mom was out using drugs. She might have a criminal record. You have like no idea what she's doing. And if she comes back after years of abandoning the child and she takes that child from you and the police is going to have to, she could have abscond. She could literally leave the state, disappear with the child, and you have no idea about that child's safety. But in addition to that, she could also argue that you kidnapped the child and you refuse to allow the child to come with her. And I've seen this happen. That's why it's very, very important. In addition to that, she can argue that you have violated the order and you should go to jail. Similarly, with the child support matter, you can also go to jail because you are considered in arrears. And if you don't get that child support order modified, or as well as the child support custody modified, you are in a world of danger. And that's why it's really, really important. And I'll just tell you, I've had dads that call my office, and the biggest thing that they seem to be concerned about really is just making sure that they are named the custodial parent, even though they have a child support order in place. And even though the child is in their home, that for some odd reason doesn't seem to be an issue for dad. Except, of course, when they get a letter from child support saying you got an arrears and you need to pay it. So in a nutshell, what dad should do, as before he got the order, he should have went to court, sought to get the orders modified for child support as well as for custody. So dads, please, if you do nothing at all, go get that order modified. Let's just say dad forgets to tell his new employer that he has a child support income deduction order and he needs to have his child support taken out. And he is technically in arrears. But then after the child has moved in with him and he's taking care of the child, and that then go and get the order modified, whatever arrears he have is going to be significantly less than what he would do or be owed if he didn't do anything at all about it. Now, what else can dad do at this juncture? Because after all, those orders are still in place. So this is the other way that these type of cases play out. So child support sends him this letter saying you owe $30,000. What can dad do at this point? Because everything is gone. There's nothing to do about it. Well, the first thing dad should do is at least get his evidence in place. He needs to be able to show the court that although there is an award, a child support order that requires me to pay child support, even though I haven't got it modified, I don't think that I should be thrown in jail or in prison. I don't think my license should be suspended. So what he should do as part of his evidence is to present to the court prove that he has had the child in his custody for a significant period of time, particularly during the time that he was supposed to be deemed or declared having not paid child support. And for all intents and purposes, failure to pay child support or to provide financial support for your child is considered abandonment, okay? So what type of evidence can dad present? Well, if the child is school age, dad could potentially provide proof that he enrolled the child in school. His name is the one signed on the list. He's the contact person. Maybe he's married or has a fiance, he's engaged. That person come and testify. Maybe there's family members. Maybe there are people in the community. Maybe his doctor's appointments, there's proof that he's gone to doctor. For instance, he had to get shots for school. Or there might be some communication between dad and mom, where mom says, hey, I need a break from this child, and she hasn't come back since. All of those things is evidence that mom has abandoned the child and dad is the one that's providing support and custody for the child. And that works in favor of dad. Now, I will tell you what dad should not do. And I have seen it, okay? The first thing dad should not do is to go to court with a bunch of conversation, talking about what happened. Yeah, the thing is, if you have to go to court and you're representing yourself and you're not a lawyer, you may not understand the process. I get it. But the court deals with evidence. So if you're unable to retain an attorney, which I recommend that you do, but if you have to represent yourself, which is called a pro se litigant, you must have your evidence. And going to court and saying, I did this, or I did that, or she did this without any evidence, the court is not likely to be able, one, follow or believe your scenario. So what you need to do is to present that. You can have witnesses, maybe affidavits, maybe you have text messages, information from social media. You might have a witness from the school say, yeah, dad has been the one that came and registered the child. Maybe you can provide a copy of the application or the child's medical bills or something that said, I am the one that took him for his doctors. Any of that stuff can help. Another thing that is helpful is to create a timeline. The court likes to see a chronology of things that is happening. So a timeline is, hey, mom brought the child to me back January 1st, 2003, 2018, whatever, and I haven't heard from her since. And that can be helpful if you have additional evidence to support it. The other thing dad could say is that I did work another job and I did forget to provide my employee with the child support information. However, I am working, I am providing for him, and I'm the one that's taking care of him now, and it's just my fault. Sometimes, unfortunately, you have to actually lay your sword, because in this instance, there's nothing that the court can do. You fail on that, and you can't blame the court for it, even if you think it's unfair. By presenting the evidence that you are now the primary custodial parent of the child and mom has abandoned the child, the court can see that you have not willfully disobeyed the court's order, but rather you did it by an omission. But at least it's not going to be a scenario where it's a willful, intentional disobedience or ignoring the order. And that makes a difference. And you want to be able to show the court this simply by the evidence that you provide. Another topic that I find quite interesting that a lot of dads have is the topic of custody arrangement, and specifically what type of custody time or parenting time awarded to the non-custodial parent. Now, there is this misguided belief that dads cannot be the custodial parent, or dads have only what's called standard visitation. Now, I'm going to be frank with you. I don't know how and where this came from, but it is nonsense. In my opinion, standard visitation is just bull. And the thing is that there are so many dads that just accept standard visitation because there's this belief that this is all he is entitled to. Now, I'm going to just tell you, you're trying to have a relationship with your child, right? There are 365 days out of a year. And in that 365 days, most months is 12, composes of 30 days. Yeah? Okay. And in those 30 days, you got 4 weeks. And in those 40 weeks, you got 4 weekends. Standard visitation says dad, who might be the non-custodial parent, is entitled to see his child every other weekend, which means that dad is only able to see the child twice in a month. Okay? So even if we say that dad was entitled to see the child 3 days and 30 days, that's only 6 days. And within 30 days, that means the child is either with mom or the child is with mom's friends or somebody mom's. That child is with anybody other than that for at least 24 days. But the reality is that standard visitation actually begins at 6 p.m. on Friday, and it terminates at 6 p.m. on Sunday. That's standard visitation. Now, I don't know what child or human being or person could ever get to know really who you are if they only get to see you about 4 days out of a month. That is not how you parent. That is not how you establish a familial bond. But there are so many people, particularly fathers, who think that this is all they have. And there are moms who think that that's all dads are entitled to. But I'm here to tell you that is hogwash. You don't have to just accept standard visitation. In my practice, I've only had one dad that insisted on getting every other weekend visitation. And he did that because of his work schedule. But I've had dads who had work schedules that were very tedious, but they had family members and people in the community that were able to help him have more visitation time. Because in my opinion, standard visitation is part-time parenting. And as a parent, you cannot part-time anything. And that is major. And so it is important that you decide whether or not you want to be a full-time parent and have a relationship with your child, or you want this called standard visitation. Now, I know there are some attorneys and some other people that are not going to like what I'm saying, but I don't support standard visitation. In my opinion, people are not standard. And why should families be giving this standard visitation? Now, in addition to that, I was looking at a barbershop talk about fatherhood. And while, I can respect dads wanting to say, I need to listen for a man, I can totally respect that. But sometimes you need to listen to someone that actually has experience. And in this scenario, these dads were talking about how difficult it is to raise their children and have custody with their children, and that they only were able to get a few days, this standard visitation. And in my mind, I'm like, this is just absolute nonsense. And of course, they're upset with the court. They're upset with mom. And my thought is you need to be upset with yourself, because there's nothing that says that that is all you can get. Oftentimes what happens is that dads accept that because they don't know. But if you want more, you have to ask for more. And there are some circumstances where the court may not award you more, but that's why you can appeal. So dads, please stop accepting the system only works for women. If you don't challenge the system, you are going to always believe that the system works against you. And the reality of it is, it's just that it's not true. You have to fight. You have to be knowledgeable. It's no different than your business. It's no different than your craft. It's no different than you working on a car. You have to learn everything about the system that you're in. If you don't know the whole system, something is going to give. So if you're in court and you got a custody case, or you're in court, you got a child support case, you need to understand that system, and the system is court. If you don't understand the system, or get someone that does understand the system, and if you accept just the bottom line, you will continue to believe that the system works for women. And I am here to tell you that it just doesn't. But what I will say, I understand that belief. And primarily because, as I've said before, dads generally don't like to fight. Dads generally don't want to fight, and they don't want the drama and the confrontation. But sometimes you got to confront what is a problem. And if you don't want to confront the issue, then you're going to deal with the BS. Just saying. Hey fathers, I hope you enjoyed this week's episode. I also hope you were inspired and you learned something new and helpful. As always, you're not in this alone. Don't stop fighting. Your children do need you. If you enjoyed the episode, or if it was helpful to you in any way, please consider following us wherever you listen to podcasts, or on YouTube, The Father's Advocate. Hit the like button, share this episode with other fathers, and subscribe. Also, feel free to leave us a comment or suggestion of topics you'd like us to explore. Please share your thoughts and participate in our online questionnaire. We would really like to know what you think. Lastly, we would like to honor fathers by hosting the first ever father-child athletic competition and father-daughter dance. If you'd like to attend, be a guest speaker, a sponsor, volunteer, or anything in between, please contact us at info@thefathersadvocate.com. See you next week for another episode. Until then, this is the Father's Advocate, Attorney Hughes.